let's go back to that assumption. Do the SCs, STs face inordinate levels of crime? Doesn't seem like it from the NCRB data, but remember, the definition of violence is ever expanding. So actually, it's a question you cannot answer with data. Here's the tricky thing. I'm already laying out that you can't answer this question with data, but I keep bringing out the data. Why? Because the same data can be interpreted in multiple different ways. So that the notion of caste violence predates any data, which also makes it impervious to data. No matter what data is or isn't prevalent, our notions about caste violence are simply not shaken by it. Remember, the UN is looking at atrocities as war crimes, genocide, crimes against humanities. And we are giving them data like 52,000 plus cases in UP alone over a 5-year period. What does that sound like to the international community? Thank you to Sangam for inviting me for the talk, but more than that, to Sarayu Foundation, because they are responsible for supporting the work that I'm doing now. The Center for Scientific Social Studies is basically a patron. The patron is Sarayu Foundation. So if there is anything of worth in this work, then the ones who are enabling it are sitting here behind you. Just as a preface, to give you some sense of where I'm coming from, in 2017, when the book Western Foundations of the Caste System came out, there was a co-authored article called Caste Atrocities, What the Data Can and Cannot Tell Us. It was co-authored by me, Sufiya Pathan, and my husband, Duncan Jalki. And it was in the book Western Foundations of the Caste System. At that time, I thought, that this is more like journalistic work, something that anyone would be able to do, doesn't require any deep research. So maybe, we'll just, it's a glitch in a research career. However, it acquired a life of its own. And here now, when I talk about the Prevention of Atrocities Act, it's because I am looking at a larger story, not just about where it started, which was the data on atrocities, but the act itself, how it came up and what happened. But the thing is, I haven't been able to finish the story yet. I've just started out. So I'm not going to be able to tell you the story of the act. I'm going to tell you the story, hopefully today, of what has compelled me to look at the act. And I'm hoping that all of us can have the discussion in a way that is dispassionate, because although there is a lot of emotion attached to these issues, traditionally Indians have always recognized that if you are going to learn something, you will have to put aside emotions and think about the questions logically and reasonably. So I'm hoping that we will have a few points that we can take forward or ask ourselves about through the talk in relation to the kind of work that is undertaken under the POA. Okay, so this was the story. We started in 2017, and the article pointed out that here are the basic points of consensus. The caste system generates violence. The violence is by upper castes against lower castes and scheduled tribes as well. So that is one. Second, therefore, SCs and STs face inordinate levels of violence in society. this violence is always on the rise, and this violence takes varied forms. Another way of making that claim about varied forms is to say that this violence is disguised. So this was basically the starting point. This is a consensus in academic literature that we find, not just academic literature. Since we started the work, I found that this consensus stretches way back into the 1970s and late 60s in parliamentary debates and reports as well. So what I want to do is to come back to this consensus at the end and see how much of this we can justify, right? And before I get to these, come back to these, I'm going to also highlight some of the features, the brief timeline of the POA, some of the features of the POA. What do I mean when I say POA? That is the Prevention of Atrocities Act. Okay? Now, so the Act comes into force in 1989. It is the result of almost 15 years of tracking by the Parliament, and debates, etc. Again, like I said, I'm not going to be able to go into a detailed history of that today. Hopefully, the work will come out at some point. And it gets implemented in January 1990. It's further sort of not expanded but elaborated. Rules are related to the POA, whether there will be special courts, how those cases should be dealt with, special police stations. So there's a sense of putting together a machinery to deal with or to implement this act that is put together by 1995. Another important element is that in 1995, the National Crime Records Bureau begins to systematically record the cases against SCs and STs, which is castes/atrocities, against SCs and STs separately. So the next important event is 2015. The amendment of the Act, which happens under the BJP government, and it expands the list of already fairly elaborate set of atrocities that were already included in the Act. They expanded it further. In 2018, we have a case, and the POA suddenly becomes a point of discussion. This is the Subhash Kashinath Mahajan versus State of Maharashtra case. I'm not going to go into the details of the case, but basically the Supreme Court made certain observations during this case, and besides the observations, it also about the case, it also made observations about the POA itself, and that led to widespread protests. So what was it that the Supreme Court was saying? The POA does not allow for anticipatory bail, and it also limits the kind of bail that can be. So, for instance, the nature of the crimes for which bail is applicable under IPC is greater, whereas under POA it is narrower. So you have less access to bail under POA than you have under IPC. Just to give you a sense, IPC, Indian Penal Code, right? The POA works in tandem with the IPC. It is like an additional set of criminal procedure, right? Okay. So the Supreme Court made observations like, if there is no scope for preliminary inquiry, which is the case in arrests under the POA, then there is scope for misuse of the POA. And therefore, it recommended that there should be some kind of preliminary inquiry, as happens before any arrest, even under POA, so that the act is not misused. It also made the observation that when it is an arrest of a public servant, we need to uphold a rule which is already in place, that in order to arrest a public servant, you need approval from a higher authority within the organization in which the public servant works. In the case of Subhash Kashinath Mahajan, for instance, he was able to use that clause in order to safeguard himself, and the Supreme Court upheld that that is an important feature that should not be infringed by the POA. Like I said, it led to widespread protests by Dalit groups who said that this was a dilution of the Act, and they were absolutely unhappy. The protests happened in April. By August 2018, Parliament passes an amendment to nullify the Supreme Court judgment, and it reinstitutes the original provisions of the Act, whereby no preliminary inquiry is required, and you do not need a senior official to sanction the arrest. Okay. Again, in 2018, the amendment is upheld. In 2020, another Supreme Court case overturns the previous Supreme Court judgment and says, indeed, the parliamentary amendment is correct, the Act should not be diluted, and we will reinstate completely all provisions. However, again, in 2024, August, we are up against the same question with another case, Shajan Skaria versus State of Kerala, and the ruling allowed for, this is a Supreme Court ruling which allowed for anticipatory bail. So, the story keeps going up and down. The main focus so far has usually been on the area of anticipatory bail, okay, and preliminary inquiry. All right. Now, while our public contestations have always been about these features, which is anticipatory bail and preliminary inquiry, and the general sort of reach of this Act, there are actually far more fundamental questions that we are not asking. So, for instance, what is an atrocity, right? There's a very good article published in 2022 by Nihar Sashital, and he raises the question, what is an atrocity? And he says the United Nations has used it in three ways, which is genocide, crimes against humanity, and war crimes, right? How do we use it in the Indian context? Any crime against an SC or an ST by a non-SC or an ST, as long as the perpetrator of the crime knows the caste of the victim, is an atrocity. Okay? This is our definition of atrocity. So on the one hand, I want you to remember how the UN defines this: genocide, war crimes, crimes against humanity, right? Here we say whether it is theft, whether it is arson, whether it is rape, whether it is murder, whether it is insult, all of those, any crime against SC, ST individuals, so long as it can be established that the person who perpetrates the crime knows the caste or tribal background of the individual, is an atrocity. I've put down 3 points there, which I recommend all of you please read the POA, because it's interesting to see in what detail we have listed the kinds of crimes that would count as an atrocity. And the scope is really quite wide. And the 3 that I've listed here are the ones that came up in 2016. They were 2015. It was when the Act was amended in order to be even more expansive, that we added elements like any action that destroys, damages, or defiles any object, which could be a statue, photograph, portrait, anything, that is held sacred or in high esteem by members of the SCs and STs would constitute a caste atrocity. Next, by words written or spoken, or signs or visible representations, or otherwise, attempts to promote or actually promotes feelings of enmity, hatred, or ill will is an atrocity. By words spoken or written, or any other means, disrespects any late person held in high esteem by members of the SCs and STs, right? These are all, under the expanded view, atrocities, which basically is, you need to understand that this is not just the definition of particular crimes. Remember also what is attached to it. The properties of the POA are that you have non-SC, ST individuals have a limitation of their fundamental rights. You have a limitation of your right to habeas corpus, for instance, if the crime is against an individual of the SC, ST group, and the nature of the crime could be a perception of insult. Okay? That is something to think about. We might make the claim that in some cases, you have to infringe fundamental rights. We do that very often with crimes that are, for instance, crimes against the state, etc. We immediately limit fundamental rights of the individual accused. Do the crimes that are listed here attract the same kind of seriousness and the same weight? Under law, today, they do. And that is why we need to understand why or how they attract this kind of weight. Okay. Before I move on, just some other features of the POA which have attracted attention. Compensation. I will go into, there are 5 dimensions of the POA. Most people don't realize it. Compensation is one of the elements. So, to begin with, compensation was on the basis of an FIR. Of course, now things have changed. There is a sort of staggered compensatory mechanism, but there's some ambiguity about this mechanism, because remember that the POA is a little bit complex. It is an act that is upheld by state governments in conjunction with the center. So the state governments have a certain level of leeway in the way that they go about with features like implementing compensation. But there are 2 interesting cases, again very recent, 2022. The Lucknow High Court made compensation conditional to conviction and not to charge sheeting. Okay, that was not the case earlier. You could claim compensation as soon as a crime was registered. In December 2024, the Delhi High Court ruled that compensation is conditional on the case being pursued, which meant, and this was the matter in this particular case, the individual had reached a settlement with the accused. After the settlement had been reached, he continued to claim compensation, and it is at that point that the Delhi High Court ruled that if you have reached a settlement, you are no longer eligible for compensation. The High Court at this point also made the claim that compensation is given in order to allow the victims to actually gain justice, to go through the process, the legal process. I don't know if they will be able to uphold that, because in the Act, compensation has never been defined as something related to only allowing the victim to pursue the case. So it remains to be seen whether these cases will also find challenge. Another interesting element of the POA. So I'm telling you these things because these are largely elements of the POA that I began to read and understand about only after the publication of the previous piece. And I found it quite striking that this is the structure that we've created. What is the structure? So the POA, the funding for the POA is shared by center and state. The condition is that if the state exceeds its budget under POA expenditure for a particular year, and only if it exceeds its budget, the center will contribute 50% to the state budget under the POA. Okay? So, we are incentivizing greater expenditure under the POA. Now, it's interesting. I'm not sure whether there is something there or not, but if you look at the data of incidents of crime as well as of expenditure under POA in the union territories, because they don't have this structure, it's directly under the center, you will find that only 0.8% of total expenditure under the POA by the center, I'm not even taking the state contributions, only 0.8% of total central expenditure under the POA happens is directed to the union territories. This is lower than the population. If you say there's some kind of correlation, the population, SC/ST population in the union territories is 2%, the expenditure is 0.8%. I say this with a caveat because in general, when I look at the data, I find over the years, there is no correlation between size of population of SC/ST and either incidence or expenditure under the POA. Okay, so this is again a slightly strange phenomenon. Keep in mind, what I want to do is simply to share with you the kinds of anomalies that I began to come across when I started looking at not just the data, but the larger process at play behind the POA. How many of you are familiar with this term, the Cobra effect? No? Oh, it's a story about Delhi. I thought you would know. British. Yeah. So late 19th century, early 20th century, the British government is pareshan because of the cobra population in Delhi, right? And they think of a great idea, which is incentivize people, like you come to the municipality, submit a dead cobra and get a compensation, right? So what's to lose, right? Suddenly, they begin to realize there's a problem. Why? Because the population started, I mean, not the population, but some individuals in Delhi who were smart began to breed cobras and submit dead cobras to the municipality in order to get the rewards. Which means by the time the British government wisened up and said, hey, no, we're breeding cobras instead of getting rid of them, they said, yeah, this won't work, and they got rid of the incentive. What do you think happened? The cobras were released. What else could happen? So the population of cobras increased. Yeah? Just a story for you to think about. Yeah? Okay. Now, another anomaly. This is a graph only collating the incidence of expenditure over 2018 to 2022. Just so I'm clear, the source is for expenditure is the annual reports on POA that are released by the Ministry of Social Justice and Empowerment. And there are various heads. I'm not going to go into the details, but this is the central expenditure on POA. Keep in mind, 50% of expenditure is by the states. Okay, so central expenditure These are the figures. Uttar Pradesh leads by far. Madhya Pradesh, Karnataka, Rajasthan, Odisha. Just keep a track of who are the key players here, right? But this, that is the expenditure. This is the incidence of crime, right? Uttar Pradesh leads, Madhya Pradesh is next. But Karnataka is not third. Karnataka is ninth in incidence under POA, but it's third in expenditure. Okay. Similarly, Bihar is ninth in expenditure, but it is fourth in incidences. Yeah. How is this possible? So the first time I saw this and I realized, I said, how is it possible that cases are fewer but expenditure is higher? My ignorance. Because the POA is not simply an act which is either just compensatory or punitive. It has 5 dimensions, which is, third is to establish legal support. Establishing legal support, as I mentioned earlier, there are a variety of different ways: establishing special courts, special police stations, giving lawyers to victims for free, giving transport charges to allow victims to come to courts. So there's a whole mechanism of support that the government had put into place. That establishment of legal support is under, the expenditure is under the POA. An element I was not aware of is the incentivization of inter-caste marriages, which is also an expenditure under the Prevention of Atrocities Act. Okay. In 2023, Rajasthan, now here's the problem. When you start looking at this, as happens in the Indian context, कोई सीधी कहानी तो हमने लिखी ही नहीं है, उसमें मोड़ ही मोड़ आते ही रहते हैं. So again, when it comes to incentivization of intercaste marriage, you have to understand that it happens at multiple levels. The POA is only one level. Okay, states incentivize intercaste marriage, not necessarily under POA, but separate expenditures allocated. The center also has schemes that incentivize intercaste marriage that do not work under the POA. Okay, so the from indirect calculations of how much we spend on incentivizing intercaste marriage, I can say that about 23% of expenditure under the POA seems to be going to incentivizing intercaste marriage. Now, that is only one section of the total expenditure on incentivizing intercaste marriage. For example, Rajasthan has taken a big leap and said that it will incentivize intercaste marriage with a whopping 10 lakhs, right, as incentive. Please understand, when you talk about intercaste marriage, don't get excited. It is very specific, right? It has to be a SC/ST with a non-SC/ST. That is the only definition of intercaste marriage. I'm not eligible, right? Unfortunately. So, yeah.
Male, female? No, either ways.
I think it is male-female because there are varying rates of incentivization. If it is an SC girl, there's a different rate in some states, and if it is an SC boy, SC/ST, it's a different rate. Yeah. Again, like I said, we've never told a straight story, so every state is a different story. But just to share with you the kinds of interesting tidbits I came across in relation to Rajasthan. In 2014, the Rajasthan government had to make certain, create certain rules about the SC/ST incentivization. And they said the couple, the age of the two individuals who are applying must not exceed 35, because they had cases of people who were 60 plus who had gained incentives under this scheme. They also had to introduce other elements, like they said half of the incentive will be given at the time of the marriage, half will be kept in a FD for 8 years and is dependent on the marriage surviving. Okay, so how many of you have heard of organizations like Love Commandos? आप दिल्ली में रहते हो? Well, please look them up. They're heroes, right? And it's, as usually happens, we don't recognize our heroes until foreigners do. So there were multiple foreign documentaries about the Love Commandos. And finally, then our YouTubers caught up and started creating some material. There are multiple organizations like the Love Commandos, though I think the Love Commandos is the original sort of pioneer. Who are the Love Commandos? The Love Commandos is an organization which runs, they call safe houses. Safe houses for couples who are, who want to have a love marriage, but are facing opposition. And so the couple comes to this organization. They have to submit their phones, their documents, everything. They have to remain untraceable because their life is under threat. And the Love Commandos help them to get married, right? So one of the, so far in the material that I have looked at on the Love Commandos, nothing, although there were allegations about how they take money from the couple or extort, and there's a case also against, what is his name, Sanjay Sachdev, right, which came up in 2019 about extorting large amounts of money from the couples that come to them. What has never been highlighted is that they actually are able to run these organizations because they understand very well the structure of incentivization that is available, not just from the couple, but from the government, right? And not just the central government, but state governments. And it is this knowledge and their network with the police that they use in order to run the safe houses. And I think Mr. Sanjay Sachdev was exonerated recently in 2024 and the charges were dropped. But it's interesting that nobody in whether journalistic circles or others have raised the question, what sustains organizations like these? Please understand, society is dead against all of this, right? Yet organizations run and thrive for decades. How? Surely we need an account of that, right? Okay. The fifth point which I didn't raise is there's also money earmarked for awareness programs under the POA, awareness of caste and caste system related issues. It's not easy to demarcate how much expenditure happens on each of these heads because we don't have a clear breakup. What I gave you under expenditure of inter-caste marriage incentivization, you have to calculate that by looking at state figures, calculating the number of couples incentivized, and then come to that. So I can't tell you exactly how much is spent on each of these heads. These were the stories, if you like, right? The interesting things surrounding the POA that kept me hooked. I began to wonder, there are many unexpected things that are coming up in my readings in relation to this. So what is the problem? Am I saying there is corruption at play? Possible, right? The stories seem to indicate that all sorts of things are happening. People are pretty wise, as the colonial government also realized, and we use whatever opportunities we get. But surely that's true of all government policies, right? It's not just the POA or any other act that is subject to this kind of corruption. So am I saying it is the definition? Yeah, at some level, yes. But it's not only that either, right? For instance, the 3 points that I put out, they're subject to fairly wide interpretation. For example, am I always in the know of which figure or which artifact would be considered either sacred or important or significant to a section of society before I speak about it? And if not, then that definition does put me at risk when I speak about a wide range of things, right? So definition, yeah, we could definitely do better there. But what I want to focus on today is to try to get you to realize that these are not the same level of problems that we have with any old government policy or act. These are far more foundational, right? And that is why I remain intrigued by what we're doing under the POA. And that is hopefully what I will point out next. So, for example, we incentivize intercaste marriage because we believe that it leads to social integration. Okay? Let's look at case law. Do the two individuals who get married, do they integrate in one caste? No. Your case law says that even if you have married Valsamma Paul, but there are others as well, this is a landmark case, Valsamma Paul, case of seeking SC reservations by marrying into an SC, marrying an SC individual. The case, the court held that no, you do not get the reservations. Why? Because if you are non-SC, then you have not suffered the disabilities of the SCs and STs, and the privileges that are earmarked are for the SCs and STs because of the disabilities that they have suffered. So it plays fraud on the Constitution. This is, I'm quoting from that case. It plays fraud on the Constitution to give a non-SC, ST those privileges. Therefore, by marriage, you do not integrate into another caste. Okay? The Rajendra Srivastav case was interesting because this was a case where the wife was SC/ST, the husband was not. It was a case of domestic violence, and the question was whether the POA can also be added in this case of domestic violence. In the observations that the court made, this happened at 2 levels. One of the levels was that it should be allowed to attract the POA as well, because just by marriage, the woman does not lose the disabilities that she has by birth. Okay? What about... So social integration is not by the couples marrying, right? What about the children of such intercaste marriages? Do they not have caste? Do they have an integrated caste? Or do they have? No. Even there, the case law, although much more complex, still has a certain identifiable thread. Usually, the children take the caste of the father, unless the father has been absent and the mother has been raising the child. Then the individuals, the children, take the caste of the mother, which has to be established in court, right? So, our legal opinion says that we cannot integrate one caste to another. Here is what logically follows. Integrating castes is not required for or implied by social integration, right? Okay. If intercaste marriage leads to social integration without caste integration, yes, then on what grounds are we saying that the caste system is a challenge to social integration in the first place? However, caste integration is required for social integration. Then how does intercaste marriage help? So what are we incentivizing? Right? Please understand, we do have all sorts of things that we think are good, right? Like, I generally think that people should marry later rather than earlier, right? But we don't incentivize that, or at least the state doesn't incentivize that. So there are a range of things that we may consider good, but we don't necessarily incentivize. When we incentivize something, we must, like I said about how the POA puts restrictions on fundamental rights, you must have very strong justifications. Similarly, when you incentivize, you must have justifications. By case law, it seems like we are contradicting the very basis of what we are incentivizing. Okay? Back to the data, where my journey began, right? I'm not going to go into the details of the data today. It has been talked about in another video, etc. But let's just draw out a few features that I've highlighted before. On the one hand, the data has been used to signal great alarm, right? Look at the huge incidence of crime that is visible under the POA. Ironically, at the same time, the data hasn't gained any attention. And what do I mean by this? It's not as if people are not. Journalists every so often will say, in UP, this is the incidence, or it has risen by this percent, or etc. That's not what I mean. I mean, if you are alarmed about something, surely you will study it, right? You will look at the data and study it with care to understand trends and to understand where it varies, what's going on. Are there things that you can identify either as historical background or regional background that will help to understand the data? And I have seen zero evidence of this, which is very strange because the data alarms us. Yet, something that alarms us does not provoke serious study. How come? Because whenever the data is used, it comes alongside with an assumption. What is the assumption? The assumption is that the data is not accurate. Okay? This is not an accurate reflection of either crime or atrocities that the SCs, STs face. It is just a fraction of what gets reported. The problem is much bigger. So therefore, you may use the data only as an indicator of sorts. It doesn't give you a sense of the scope of the problem. Now, this is true of crime across the board, right? Any category of crime is underreported usually. But the claim when it comes to the data of crime under SCST, POA, is that this is especially so. Because the system is weighted against them, so they don't have the opportunities to be able to gain access. So my question is, if the data is flawed, then what you are looking at is a broken scale. Yeah? But that's not how we use it. We don't say, well, when I put, let's say, this bottle on the scale, at one point it shows me 200 grams, at another point it shows me 500, and at another time it shows me 700. I can't use it. Because there you're not sure, is this 200 or is this 700? But here we are sure. It's always 700 or more. So it's an indicator that it's always greater. Yeah, we don't consider it a broken scale, we only consider it a partial scale. Okay. And the sense is that the violence itself in society is much greater. The underlying justification is, in fact, if there is any crime that is still being registered under the POA after there being such a strict law, then you have to realize that there is indeed a huge amount of violence that is always prevalent. Okay? At this point, I want to raise a question about what data we have. Now, although this began in the 1970s, it becomes formalized in 1995 when the NCRB begins to put out data of all crime against SCs and STs. That's one head. And it also gives crimes against crimes under SLL, which are the special laws. And the POA is one of the special laws, right? So what you have is data that aggregates crime under SLL, that is only POA, but all crime under IPC as well. That's the only data you have. You do not have a data which disaggregates what has been registered or has been proved to be an atrocity and what hasn't, because that only happens in court, whereas the data is provided by the police. And this trend, this practice, in my article, I thought it was the academics and the NCRB. It's not. It's actually the Indian Parliament in the 1970s that established that since it is difficult to gauge what is or is not an atrocity, all crime against SCs and STs, especially if it is by non-SC ST, will be counted in data as atrocity. I'll come back to this general consensus, which I've put down again over here, to give you a contrast. The contrast is the NCRB also produces a report. The NCRB annual report also produces tables for motives for particular crimes, right? Especially murder. And I'm only giving you a sample. They have a wide range of motives. And for 2022, when I look at the range of motives by motives for murder in the NCRB data, there are two relevant ones for caste atrocities. There's casteism and there's honor killings. So the total of that is what, 45 as murders that have taken place that you can call as atrocities. But the data which breaks down crime/atrocities against SC/STs for 2022 under murder gives 219 as incidents of crime/atrocities against SCs and STs. The motives tell us 45. The data by NCRB, which is reported as atrocity, gives 219. Okay. This is only 1 year, of course, but you can systematically study and see whether the motives align or not. So to come back to this question, the caste system generates violence which is directed by upper castes against lower castes. When the NCRB registers the crimes. It does not register the caste of the perpetrator. So we have actually no data to tell us which section of society is, or let's say, whether there is a preponderance of any particular section as perpetrators against crimes, in crimes against SCs/STs. We have no data that indicates that. Okay. When we say upper castes, we generally think of Brahmins, Kshatriyas. We don't think of, for instance, the OBCs, right? But when you study the major incidents of caste atrocities that have taken place, you will find a strange trend. The trend seems to be heavily that of conflict between OBCs and SC/ST groups. Okay? Ironically, this should be reported as crime amongst lower castes, but that's not how we think of it. We still think of it as crime by upper castes against lower castes, right? Why? Okay, all right. Do SCs, STs face inordinate levels of violence? So we had taken an approach in the previous piece where I looked at crime against SCs and STs, looked at the percentage of that crime, and looked at, therefore, the incidence against the total population. I'm not going to talk about that right now because a much better approach was taken by Mr. Nihar Sashital, whose article I mentioned in the beginning, and I'll show you his findings, which are better in some sense. So I'll come to that. The third point, this violence is always on the rise. Yeah, well, gross figures are across the board always on the rise, right? Is it true that in terms of percentage of crime, this is on the rise? Again, Nihar Sashital's work, I would invite you to look at that article, shows that it has in fact a certain kind of plateau since the beginning of the data itself, since 1995. It is not, the percentage is not on the rise. The last bit, this violence takes varied forms. Now this one is very tricky. And it undercuts, like I said, it no longer it becomes a question of a broken scale or anything else, because this means that anything may be counted as violence, whether it is access to public services, access to public spaces. It is a huge variety of things, right? All can be considered violence against SC/STs, and I can't even think of a study that will actually be able to document this in its scope, because there's that much. But the question that we need to answer is, if violence is forever disguised, right, then what is not violence? Just so you understand, if anything could express violence, we just don't realize right now that it is violence, then how will we be able to identify there's a set violence? What is the counter set? Or what is outside of that set, which is not violence? Ironically, we have no way of delineating what is not violence anymore when we use this yardstick. Okay? Okay. If I can, I'll come back to this data, but what I promised you about Nihar Sashital's work. So what he did was, instead of taking gross figures of violence, he said, let's look at serious crimes. Okay? And let's see whether SC/ST groups face an inordinate level of serious crimes. So if you look at this data, the level of crime when it comes to murders for the general population is much higher than for SC or ST groups. Similarly, rape against the rate of rape in the general population much higher than SC/ST groups. When it comes to grievous hurt or just hurt, again, rate of crime much higher in the general or non-SC/ST group than within SC/ST groups. Let's go back to that assumption. Do the SCs, STs face inordinate levels of crime? Doesn't seem like it from the NCRB data, but remember, the definition of violence is ever expanding. So actually, it's a question you cannot answer with data. Here's the tricky thing. I'm already laying out that you can't answer this question with data, but I keep bringing out the data. Why? Because the same data can be interpreted in multiple different ways, right? And I earlier showed you an aggregate of POA incidents for the period 2018 to 2022. This is showing per year incidents. And of course, UP is on top, Madhya Pradesh is next. This is the top 10 states for incidents of POA, incidents under crime/atrocities against the SCs and STs. Now, just by a visual representation of this data, you may be struck by something. It looks like 4 out of these 10 states seem to express much higher levels than the others, right? In fact, they express 64.65% of all incidents. Now, my question is, if you're serious about the problem of caste atrocities, why are we not raising the question, what is happening in these 4 states? Why are we always discussing a pan-Indian problem when the data seems to be indicating there's a far more severe incidence in a limited group? Yeah. 2/3 of all incidents is taking place in these 4 states. If you add the 5th state, then that counts for 70% of incidents, right? So if 30% of your country, 30% of incidents is in the rest of your country, it's minuscule, relatively. And 70% is in one set of states, right? Where are the studies that will tell us what is happening in these states? There are none. So when we started looking at the data, one of the things, like I said, we looked at the general data for the population and said SC/ST population faces the incidence of crime, if you compare it to the overall incidence of crime, is 30 times less. Right? So the statement that many people picked up from the first video was SCs, STs face 30 times less crime than the rest of the population. There's an amendment required. Why? Because you can't actually aggregate crime in this way. Yeah, within all crime statistics, when you take all of crime, you also include crimes that are against the state, or that is, for instance, narcotics or other such acts which are not directed against any section of the population. So this statement doesn't really hold, but it's still giving you enough indicator to uphold what? The claim that we made, which is that SCs and STs do not seem to face inordinate levels of crime. That much we can still uphold. The second amendment that I would make is that we had said that this is a trend to look at crime as atrocity. It's a trend that is amongst academics, but only now I realize that it is not. It was in fact foundational to the definition of atrocity that we came up with in this country. Okay? Now, what I'd like to raise as questions. I've raised a few anomalies. There are things that should puzzle us, right? We can't really solve what's going on. There's something not quite fitting. So the question is, how do we know we are solving a problem by creating acts or provisions like the POA when our data is not corroborating the story from which these acts or these measures have come out? For instance, are we sure that we are not creating problems instead of solving them? Another thing, if you equate, let's say, insults with murder, right? Are you not definitionally diminishing serious crimes? And please remember, caste atrocities, the definition today is any crime, but we inherit the word from a particular history. The history that we saw in the late 60s and 70s, partially also the 80s, which is a series of gruesome incidents that were unfolding in the Indian context, whether it was murders, parading women naked, all sorts of different kinds of incidents, which we refer to as caste atrocities. And today, when we talk about insults in the same way, or we talk about inadequate respect for figures in the same vein as we talk about murders, are we not diminishing the occurrence that we witnessed then? An even more serious question, are we even attempting to explain those incidents? Surely, those were incidents you want to take seriously. You want to come up with accounts that allow us to understand, thereby defending us against future such incidents. Instead, we talk about them as caste violence as if it explains the situation. So therefore, this acts as a placeholder explanation, if you like, which prevents actively research into specific and very important regional or caste relations that needs to be taken up in order for us to understand the Indian reality. Okay? One of the things that we know is that the notion of caste violence predates any data, which also makes it impervious to data. No matter what data is or isn't prevalent, our notions about caste violence are simply not shaken by it. The logic of caste violence has always been, it is a tool to uphold the caste system. The upper castes use it in order to sustain the caste system in place in the face of an Indian government that wanted to abolish the caste system. Caste violence became a tool for the upper castes. If so, then by our own accounts of the caste system theory, the group that has the highest stakes are the Brahmins. Interestingly, when you look at major atrocities that have taken place, the Brahmins are absent completely in any of these incidents. A point I already made, if caste violence is always disguised, right? You cannot identify what is or isn't violence. But here's a question. The same kinds of problems are prevalent in other sections of society as well. But when they become prevalent in an SC/ST group, you see it as a sign of violence, whereas in another group, it is not a sign of violence. right? Whether it is access or it is patterns of ownership or of land especially, or it is even dropout rates, which have been used to talk about caste violence. But dropout rates are not a phenomenon that are specific to this group. They're across the board, right? What makes it violence in this group, but not violence in other groups?
Recently, temperature in Delhi was also quoted as specifically, just 2 days how it came in the news. The temperature in Delhi, how the weather is more detrimental to the lower castes. Just 2 days ago. Take on the newspapers.
Yeah. 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 Yeah, absolutely. But here's another question, and this is the one that I want us to take very seriously. What does the data, we use the data almost as if it is a use and throw, right? But what does this data sound like to the international community? Do they understand, considering that I didn't understand, that the data is any crime of huge scope, like difference in severity, is being recorded as a statistic within the data of crime against SCs and STs? Does the international community understand this? No, because remember, the UN is looking at atrocities as war crimes, genocide, crimes against humanities. And we are giving them data like 52,000 plus cases in UP alone over a 5-year period. What does that sound like to the international community? And now consider the last point, which is we have sat pretty in the Indian context, not having to challenge or question the logic that was used, established right since the 40s to 70s or 80s when these laws began to be established. But here's a newsflash. Caste litigation is no longer an Indian domain. You have caste litigation that is happening in the US, in the UK, and being considered by the European Parliament. Right? And here's the last thing I want to leave you with. There's a striking similarity between the structure of the POA and the kinds of features that the POA uses. Like, for example, burden of proof is on the accused, not on the victim. These features are also expressed in the structures of international laws that are coming up. I'm not drawing a causal link that requires study, but I am saying that we seem to be teaching the West how to deal with this question. But do we know how to deal with this question? And what question are we dealing with? I'll leave it there. Thank you.
Sufiya, this was fantastic and such an eye-opener. My question is very literal. When you found the data on the perpetration of violence in these states, did you also find that the proportion of cases was also proportionate to the populations in these states? Because these are large states. What
Not proportionate. I do not find any significant correlation between populations of SC, ST and incidents of crime so far.
I'll start with the last comment you made. Because I happen to be one of those, जब ये SC/ST एक्ट आया था तब से शोर मचाना शुरू किया था मैंने.
अच्छा.
हाँ. और केसेस, क्योंकि मैं लीगल एड बहुत किया है, तो ऐसे केसेस बहुत जल्दी आने लग गए थे, जैसे डोमेस्टिक वायलेंस के भी, मिसयूज के वगैरह वगैरह. तो एक तो शर्म की बात है कि हिंदू समाज पढ़ता ही नहीं कानून जो उसके ऊपर लागू होते हैं, सोते रहते हैं। जब पिटते हैं फिर वो ही पढ़ते हैं जो पिट रहे हैं और नहीं पढ़ते। खैर वो पुरानी बीमारी है। Now your last point was that the way this data is coming to the is being presented to the international community, तो वो लगता है कि हिंदुस्तान में तो एक्सप्लोड हो रही हैं हेट क्राइम्स
बिल्कुल
अगेंस्ट, और आपने कहा कि हम उनको सिखा रहे हैं
बिल्कुल
ना, बट फैक्ट ऑफ द मैटर इज ये सारे कानून स्टार्टिंग विद लॉज फॉर द एम्पावरमेंट सो कॉल्ड एंड प्रोटेक्शन ऑफ वुमेन, ये सारे फॉरेन फंडेड एनजीओज लाए हैं। इनमें से एक भी हमारी पार्लियामेंट में ड्राफ्ट नहीं हुआ, डिस्कस नहीं हुआ। आई बीन विटनेस टू दिस, एंड बिकॉज एट ईच पॉइंट when such cases were coming up, I was actually not only writing about protesting, but went to parliamentarians. They had no say. The bureaucrats had no say. They all came ready-made, just as the anti-rape law came ready-made. The Verma Commission didn't even do एक कॉमा फुल स्टॉप बदलना भी नहीं। वो इंदिरा जयसिंह और वो सारी उनकी माफिया बैठा हुआ था, पहले तैयार था वो कानून। तो ये सारे कानून, be it anti-dowry act, they all suffer from the same pathology, which is burden of, firstly, definition is fuzzy. Be it of dowry, be it of rape, be it of caste atrocities, be it of XYZ, each one has bizarre fuzzy definitions. I've written extensively on this. But when you went, whether I went to the law minister or whoever I met, each one said, sorry, beyond us. हाई कमांड, तो हाई कमांड का हाई कमांड बाहर बैठा हुआ है। तो आप प्रधानमंत्री के पास जाके भी, जो मैंने किया, उनके पास भी अथॉरिटी नहीं थी। लॉ कमीशन के पास जाके भी कई बार मैं गई और उनको कहा कि इसको रिव्यू तो कर लीजिए, पढ़ तो लीजिए। ऑनर किलिंग्स का ये जो कानून बन रहा था, that was the only one we were able to stall. I appeared for Khap Panchayats personally in Supreme Court. But when I asked the Law Commission to at least read some of the facts we had presented, you know what the chairman said? I said एक कमेटी बिठाइए और ये जो आप SC/ST एक्ट वगैरह इसको रिव्यू कराइए, इसका कितना मिसयूज हो रहा है, और it's inbuilt into the law. The commission chairperson said, what does Indira Jaising and Grover think about it? I said, उन्होंने ही तो ड्राफ्ट करवाए हैं, तो obvious. In that case, Madhuji, I'm quoting verbatim. In that case, Madhuji, sorry. I mean, you have a point, but it's beyond us. This is the reality. Whether it's representation of women in parliament, जो उल जलूल कानून बनाया गया, किसी में भी ना तो हमारे किसी ब्यूरोक्रेट ने पढ़ा न सोचा, ना किसी पार्लियामेंटेरियन ने पढ़ा न सोचा, न लॉ कमीशन में बैठे लोगों ने पढ़ा या सोचा, ना जस्टिस वर्मा ने जो रेप लॉ लाए हैं पढ़ा या सोचा। ये सब उनको रेडीमेड दिए गए। जब ये परिस्थिति है तो आप ये मत कहिए कि हम उन्हें सिखा रहे हैं। ये जो वोकिज्म वहां से आई एनजीओस के माध्यम से, फॉरेन फंडेड एनजीओस के माध्यम से, ये छुटपुटे से एनजीओस पर करोड़ों रुपया उनको दे के कुछ भी आप पास करा सकते हो। मीडिया सब, यू कैन टेल कौन कौन सा मीडिया क्या उसका प्रेजेंटेशन करेगा, कैसे हिस्टीरिया लाया जाएगा झूठे इश्यूज को लेके, जैसे खाप पंचायत के खिलाफ किया था। टोटली बोगस केसेस वर बिल्ट। So the point that I'm making is, it's not we are just passive recipients of any atrocity they inflict on us through law. And to break up Indian society, that's one part. The message, not the message, the purpose is very clear. To tear asunder Hindu society in a manner that it can never be recovered. दूसरा जो इसी के साथ जुड़ जाती है, जो draconian, tearing asunder, whether it's family, all these domestic violence law, rape law, ये वो, today the same thing. Burden of proof on the accused and jail before Even the trial has begun. Bail is so difficult. आप लुट जाते हैं. और एपिडेमिक ऑफ सुसाइड्स हो रहा है डोमेस्टिक वायलेंस केसेस को लेके पुरुषों का. कोई सोचने को तैयार नहीं, कोई बोलने को तैयार नहीं, except those who are victims. So the point that I'm trying to make is that unless we understand the dynamics from where all these laws are coming, who's pushing them and what is the agenda, there's no way we can combat them by pointing to this or that. वो दूसरा ये है कि एक तरफ ये आपने सही कहा कि किसी को भंगी चमार कहना इज इक्वल टू मर्डरिंग हिम. ये डोमेस्टिक वायलेंस में किसी को मोटी वगैरह कह देना, पत्नी को ताने भी उसी में आते हैं, एज दो यू ब्रोक हर बोन्स, सेम थिंग. लेकिन दूसरी तरफ हम बिल्कुल नहीं काउंट कर रहे जो क्राइम्स ऐसे कर रहे हैं. The rate of criminality among SC communities, just as the rate of criminality among blacks in America, is much higher. We don't count that. And there is also deliberate targeting, just as for conversion. We know that they specially target Brahmin girls, Rajput girls, this, that, and the other girls. Similarly, crimes against women, especially gruesome crimes, by SC community, वो by caste हमें figures बिल्कुल नहीं दिए जा रहे, और उसकी कोई खोज खबर लेने को तैयार नहीं. इनफैक्ट वो अखबार भी मेंशन नहीं करेगा कि ब्राह्मण लड़की को एक SC ने गैंग रेप करवाया, वो नहीं मेंशन होगा. तो उसकी पॉलिटिकली करेक्टनेस इतनी है कि उसका नाम भी लेना मुश्किल है अगर क्राइम उधर से आया है. तो ये दोनों का कॉम्बिनेशन इतना लीथल है, और सोते रहेंगे तो फिर यही होगा, पिटेंगे.
There is data that you can use to talk about the last point, because the NCRB does put out data of prison inmates. So there is indication of at least where convictions are highest. वो data आपके पास है. About the overall comment, yes, ये laws क्या हमारा constitution तक हम copy paste के माध्यम से ही करते आए हैं, वो सही बात है. लेकिन are we passive recipients? There I would say no. We are passive to the extent that we have not stopped to investigate what upholds the logic of these laws in the West, or what upholds the caste system theory, which is also a Western gift. Right? So we have been passive to the extent that we have not questioned कि ये framework क्या है. Other than that, are we passive? Ma'am, unfortunately, we are a bit too active.
Yes.
Whether it is the Congress or it is the BJP, we have been active in expanding these laws, giving them nuance and giving them extensive greater powers. That is undisputable. Are there international pressures? Certainly. But let's not think of ourselves as innocent babes in the woods. We are not.
All the points that you have made, that how these are weaponized, these laws, in order to eventually breaking up the society, I agree with all that. However, when it comes to the origin of these two areas of crimes, there's a whole huge overlap, the DV laws, the crimes against women. However, in the case of the SC/ST Act, this basic difference is there, that it is not being pushed by so-called left wing. It is being pushed very much by the so-called native Hindu, well-meaning Hindu nationalist dispensation. Look at the data from the very beginning. The BJP, for instance, it has the DNA of the Janata Party, right from Mandal Commission to the 2000 to the 1995 this thing under when it was a coalition government, along with the outside support of BJP, etc., right till the expansion in 2015 of the definition. It is all being done by the so-called native Hindu nationalist party. There is no element of left party in this. So the causal, I got your point. This is the distinction. No, but it is not the case with the ST. This is not the case with the SC/ST and the caste violence, this thing. The left wing, when it comes to bringing laws and weaponizing the laws, expanding, the left wing has nothing to do with this.
I didn't say left.
No. You said Indra Jaisi, etc. The causal districts are different.
सूफिया, आपकी कुछ पहले की स्लाइड्स में ये समझ में आया कि अगर कोई डीफाइड लोग हैं, डीईफाइड, डीटी बनाया हुआ है, जैसे से फॉर एग्जांपल ज्योतिबा फुले हो गए या अंबेडकर हो गए, तो अगर मैं कुछ क्रिटिसाइज भी नहीं कर सकता, एंड सो आई विल बी अरेस्टेड अंडर अ नॉन बेलेबल वारंट, इज इट? अगर मैं
You will not have access to anticipatory bail. Whether it will be a non-bailable offense or not depends on the severity of the crime. So it is possible that you will get bail, but you will have to depend on the interpretation of whether it is a severe
that is by the police or somebody.
by the judiciary. I mean, basically the preliminary hearing that will take place.
Okay, so I could criticize Ram, but I cannot criticize Ambedkar.
Yes.
Okay. Thank you. When Jyotiba Phule, I don't know her what year, it's 1800s, late 1800s if I'm not wrong. Tab to SC Act, I mean there was the British Raj. How do I qualify under an SC/ST Act of 1995 and whatever else if I criticize Jyotiba Phule?
Because whether the figure is in the historical past,
Even if that
or
was
contemporary,
there was no definition at that point, right?
that doesn't matter. Today it is a crime.
So today it is a definitive
Today,
retrospectively
the SC
being
status-
allocated as SC/ST.
See, it's not even problem वही है कि allocation का भी सवाल नहीं है
अच्छा,
कि मतलब अगर आज SC/ST के ग्रुप में समझिए आपको आइडिया नहीं है कि लोगों को क्या पसंद आ रहा है, राइट? व्हाट आर दे टॉकिंग अबाउट, हु आर दे टॉकिंग अबाउट, वेदर कंटेम्प्रेरी और एन ओल्डर फिगर, और आपने क्रिटिसाइज कर लिया without knowing that individual is being held in high esteem. That is the definition, held in high esteem by this group. You are susceptible to be booked under the POA.
wonderful.
Thank you. My question is regarding the data that you used.
Yeah.
Now, first thing is you mentioned that the data is flawed. Now, I just wanted to understand if the data is flawed, how does the government evaluate the impact of these incentives or schemes? That is one. And the other part is before the introduction of the law, whether any data was actually analyzed to, gauge the extent of the problem.
To the second question, the law was implemented in 1989. Since 1974, the Parliament had established mechanisms to acquire data. At some point, the data, so early on, the data was about serious crimes that are being committed against the SCs and STs. Within a period of about 5 to 6 years, that began to change. And because, and this I'm quoting from parliamentary reports, it is difficult to establish what is an atrocity or not before investigation, but you need the annual data, right? Therefore, all crimes were brought under the purview of atrocities. So even before the act got implemented, we were generating data and we were using very diffuse definitions of atrocity. That was your second question. What was your first? Please
So
remind.
first was that, if the data is flawed, then how does the government evaluate the impact of these schemes and incentives on, SCSTs and whether it has uplifted them in any manner?
Yeah. There are very few evaluations that take place by either individuals or bodies that are in a position to evaluate these objectively. Most evaluations seem to take place by government contract to agencies that are not qualified to assess these things. But that said, most scholars, if given the job of evaluating this, would most likely reproduce the dominant story. That is why I keep trying to bring your attention to look and examine the dominant story, not the data. Because even though it's very striking, there's something wrong, the data is sort of surprising, the dominant story is independent of the data. It emerged independent and it is sustained independent of the data.
Ma'am, my question is the homogeneity that the law considers for the SCSTs. It's a very big issue. In the recent judgment of 2024, the Devendra Singh versus State of Punjab, this was contested issue that they are not a homogeneous communities. And Robert F. Kennedy Center actually did a study where SCSTs, they themselves commit crimes within their lower caste. So this is a historical issue. For a context, Maharashtra has Mahar and Man problem, and this is very rabid in them in their own community itself. So how does the law actually look for SCSTs themselves? If the discrimination is happening between them, should the same atrocity act, if I consider this as a legitimate act, if the law is considering, so should this act not apply to them? So are we actually not doing not doing an antithesis to this whole argument by not applying the same act to them?
So, by definition, what happens is that crime by non-SCST against an SCST with knowledge of the caste of the victim is your definition of atrocity. Okay? So within that, if there is violence amongst groups that are within the SC/ST identification, that is not an atrocity. Right? So that's why I keep saying to describe caste violence and say caste violence is caste atrocity. No, because a whole range of different things get covered up by using that nomenclature. Okay? What it does help is to uphold this nice international picture about caste violence being upheld by or used by upper castes as a tool against lower castes. See, one of the things that we have to understand is there are incidents that we want to solve, right? Let's be serious about studying these, whether it was one group against another, or it was violent crimes that happened in a particular time. Let's be serious about studying those incidents rather than masking them by labeling them as caste violence. Because right now, what we tend to do is label them as caste violence as if it is an explanation when it's not. So you're not even looking for explanations. That's the problem. To that extent, you are doing violence to SC/ST populations as well. Because cases that you have studied in your history that have happened to them, you are still not able to explain. That is a problem.
We've had this discussion. Discrimination is considered a problem. मतलब हम जब रिंकू आप में हम सब बात कर रहे थे, रिंकू ने बताया एक केस कि अगर कोई ब्राह्मण या ठाकुर कहीं बैठा हो तो जो भी दूसरी जाति में को याद नहीं क्या बात करी थी, वो चप्पल हाथ में लेकर बैठता है, चप्पल पहन के नहीं बैठ सकता. Would it not be considered offensive? I'm assuming it does. So the state comes down on such type of practices.
Yeah.
I mean, what is your general response to this? And this is exactly what supposedly Ambedkar documents that he went through. Although I am to understand that exactly किसने क्या परपेट्रेट किया था अंबेडकर के ऊपर, वो कोई डॉक्यूमेंटेशन है नहीं, जैसा मुझे समझ में आया है. किसी ने कुछ किया, वो कौन सी जाति का था, क्या वो वही खुद ही SC/ST था, OBC था, नहीं था, ये सब कुछ पता नहीं है. बस वायलेंस हुआ था और उसको झंडा बना दिया गया है.
So, again, I don't know. It's difficult to take the questions to really answer the question. What I'll do is simply point to where the problem is. The problem is that when you use the word discrimination, right, you are inheriting a framework which is a Western framework that is invested in giving that word meaning. Okay? And you have no clue what that background is. Even I don't. That is a subject of study.
I don't understand. Just help explain. What do you mean the Western framework to the word discriminate?
So, translate the word. Indian language में आप translate करोगे तो कौन सा शब्द यूज होगा?
भेदभाव, उत्पीड़न.
विवेक.
हाँ, वो एक करेक्ट एक्सरसाइज ऑफ डिस्क्रिशन जैसे स्मिता ये वो
विवेक is to discriminate, to understand.
एग्जैक्ट डेफिनेशन बिल्कुल सही. बट जैसे you know, I'm just being a devil's advocate here, but secularism, for example, original definition उसकी स्टेट और चर्च को सेपरेट करें, बड़ी अच्छी बात है. बट आजकल सेक्युलरिज्म का मतलब हो गया है कि आप कुछ भी रिलीजियस है उसको, इट इज अबाउट नॉन, हम कोई अफिलिएशन ही नहीं रखेंगे. Any state authority cannot have religious affiliation at all is come to mean that, right?
Well, that's not true.
हिंदुओं के साथ.
That's not true because your state runs temples.
Yeah, I know, but that is the
It's
paradox.
not your definition. That is what you have to understand. See, secularism as a concept has stability because of its Christian antecedents. When you remove that word, and transplant it into the Indian context, it loses stability. And then it becomes anything and everything can be defined as secularism. मेरा secularism, आपका secularism, किसी और का secularism. So you lose stability when you transplant these concepts, which is why the way forward is not to say, भाई हम agree कर लेते हैं कि आज से सेक्युलरिज्म ये होगा, क्योंकि वो कभी एग्रीमेंट हो ही नहीं सकता है. इट हैज नो रूट और ग्राउंडिंग. व्हाट यू नीड टू डू इज टू अंडरस्टैंड द एंटीसीडेंट्स ऑफ द टर्म इन द वेस्ट. व्हाट गिव्स इट स्टेबिलिटी, व्हाट आर इट्स रेंज ऑफ रेफरेंस, एंड वेदर इट अप्लाइज इन इंडिया एट ऑल. दैट इज द प्रॉब्लम.
And that you're saying is true for discrimination as well. So what would you say to a practice like that? For example, एक और छोटा example बताता हूँ. One of my friends, he brings back मूर्तिज, for example, सारे विग्रह जो चोरी होकर बाहर चले गए हैं, he brings them back. So वो बताते हैं कि उनके दादाजी का किस्सा, when he would pass by all the people, he was such a Brahmin of such a stature that people would stand on the side and bend. I didn't see that as a problem, but somehow when he sees that as a problem, as an atrocity or as a, I don't know, discrimination or exploitation or something, just to add to this, when I go to a South Indian temple, some of the Brahmins would literally throw the prasad in my hand. Now, I saw some Ambedkarite Twitter handles who were offended by this. I mean, I'm not offended. Somehow, I'm not upper caste or whatever. I don't know what caste I am, but I mean, I thought that that's their practice. They don't want to उनका जो भी शॉर्ट्स का जो भी आइडिया होता है वो हार्म होता है, and it doesn't matter. So I don't know Should this be a problem? Am I just behaving very gently, or is this a problem?
इसमें
I-
एक्ट मायावती जी के सामने कोई उनकी कास्ट का भाई कुर्सी पे नहीं बैठ सकता, जमीन पर ही बैठेगा, जूते पहन के अंदर नहीं आ सकता। वो है असली हाँ।
So, I'm going to take it at a higher level of generality so that we can begin to think about larger questions, right?
Other practices also.
Yeah. But here's the thing. We have a conviction, or at least these laws, the way that we think about them, all of them seem to express the conviction that society is subject to corruption of all kinds. Evils, right?
Deliberate premise.
Now, it's not actually liberal. The antecedents are notions of society, its relationship with jurisprudence, its relationship with law in a Christian framework. Where, whether it is church or it is jurisprudence, all of these institutions have to safeguard society from the evils that seem to emerge. Okay? India did not come up with such a conception of society. Okay? For example, even today, we think, or we in our general parlance will say, भाई कोर्ट मत जाओ, पता नहीं कहाँ फंस जाओगे, किसकी कहाँ पहुंच होगी. So where is the corruption? In our institutions of judiciary. इधर ही सुलझाओ, society is less corrupt. Okay? This is the Indian intuition that we seem to have. So, there are two stories. Okay? Let's take it at that level of generality. There are at least two stories about how to look at the world. At least two. The Christian and the Indian. Where's the Indian story? And as long as you keep getting trapped in the Christian story about the world, when will you tell your own? Question of practices. In the Indian context, there is absolutely nothing that will stop you from changing practices. Traditions see changing practices all the time. In the Christian context, you cannot change practices because they have to be justified by truth and by theology. If there are practices you don't like in the Indian context, and there would be, for goodness sakes, 1 billion in population, the variety of groups, their interrelations, their intricate histories, obviously there will be practices that you don't like, that you have scope to criticize. But what is stopping you from changing them? And do you really think that you need the judiciary to tell you what to change? How come in other realms tradition has changed by itself? Which means that tradition in the Indian context still has the strength to respond to the times in which it exists. Tell your story.
Directly coming to the question, ma'am, this inter-caste marriages is held as the gold standard because it was so strongly advocated by Dr. Ambedkar. Taking any action to even not promoting it or to incentivize it, it will lead to that falsification of the deity, so-called. So, what is the way around that?
I it doesn't lead to falsification of any kind of doctrine that has been established. Well, let's put it like this. That is a very small part of the breaking down of doctrine that you need to do. There's much bigger, right? So the whole point that we're raising is, yes, we have had a theory of the caste system which has been upheld by very important figures till today. But that theory is not, it has collected it is under the weight of so much anomaly that it is breaking down. Okay? So this was one of the points that I wanted to raise, but it slipped my mind. So I'm glad you raised it. Aryan invasion theory is going out the window, right? The so-called Brahminical status and what it is based on seems to be going out the window. The status of these texts, the fact that Brahmins are priests, all of those are under question. The thing of endogamy as being one that upholds the caste system is also under attack. So what is happening is that there are theoretical pillars of the caste system that are under sustained attack and are being eroded. In such a situation, this area of whether it is caste atrocities or more broadly caste violence becomes the moral pillar for this caste system theory. Okay? Which is why it is the most difficult to touch. Because you can't say, at the minute you talk about it, it is saying something immoral. So that's where I want to bring it back. That the theory itself is under attack. So the figures who are associated with the theory, there is in a scientific program no problem in saying that they were right or they were wrong. As long as you make it the subject of scientific study and not ideological indoctrination. That's all.
Again, it has two parts. The first one is, are the crimes under the act cognizable? One. And, whether it's a crime against the community as such or an individual. So basically, if somebody else, makes a comment, whether anybody, from a community can file a case or whether it's like specific to one individual.
I think in this case, the person who has to file the case is the victim. I'm not 100% sure. My problem is neither do I have a law background nor do I have a statistics background, but here I am talking completely out of my depth about both areas. But I think it is the individual. But you are right to sense that the interpretation is always as a crime against the group. Just like hate crimes are seen as crimes against a group, not against an individual. There is that element embedded in it.